Webinar today. My name is Kim Stanger. I'm the chair of Holland and Hart's Health Law Group, and I am very pleased to be here to talk about one of my favorite topics, which are the HIPAA privacy and breach notification rules. This is the next in our ongoing compliance webinar series. Hopefully you've received information about that and the different topics that we're going to talk about. Today, though, we are going to cover the HIPAA privacy rules. There is a lot to cover in this hour, so I'm going to be going fast. A couple of disclaimers. Remember that this is really an overview. I'm going to hit on the high points, the things that I think are the most relevant to you, but just remember that when it comes time to actually applying this stuff, you may need to actually crack the regulations and look at them or check with your privacy officer to ensure that you've got all the nuances in place. Also remember that the application depends upon the circumstances, whether you're a covered entity, business associate. Also, you have to be concerned about other laws that may apply in a particular state. We've got we will provide to you some written resources, including some articles that I've done. I'll give you a general overview of the things that we're talking about today. But quite frankly, I do a lot of writing and speaking on HIPAA issues, and we publish that stuff for free on our website. So if you would like more information, more detail about the things we'll talk about today, chances are you can find an article I've done or forums or things like that. Just go to our Health Law blog website that's there on the slide. Okay, with that said, a little bit of background then. Remember that HIPAA is just part of the privacy rules that are out there, right? And sometimes those, overlap, sometimes they conflict. For example, you've got 42 CFR Part 2 that may provide greater protection than HIPAA for SUD information. You may have state privacy laws. The FTC is getting more involved in privacy issues, so you may have those types of concerns. Just remember that HIPAA is the floor of patient privacy. To the extent that there's another law that's more restrictive, like Part 2 or your state law, then you've got to comply with that more restrictive state law. But let's talk about the privacy rules. HIPAA is short for the Health Insurance Portability and Accountability Act. Note that it is HIPAA, not HIPPA. For violations of HIPAA, when it comes to enforcement, did you know you could go to jail for this? There are actually criminal penalties that apply if an individual obtains or discloses PHI from a covered entity without authorization. The penalties can range anywhere from $50,000 and 1 year in prison up to $250,000 and 10 years in prison. Now, this is important, not only because you want to stay out of jail, but you may have employees who say, what do I care about HIPAA because I'm not a covered entity under HIPAA? And you could say that is certainly true, but did you know you could go to jail for violating HIPAA, and therefore you need to make sure you're complying even if you are not a covered entity. But for most of you, you're concerned because you are covered entities or your organizations are covered entities, you're concerned about the HIPAA civil penalties. Just like everything else in the world these days, the price of HIPAA violations is going up. The current penalties are anywhere from $141 to $2 million per violation, depending upon how bad your conduct is. If you did not know and should not have known of the violation, it's $141 to up to about $71,000. If the violation was due to reasonable cause, about $1,400 up to $71,000. In either of those cases, if you don't act with willful neglect, then guess what? As long as you correct the situation within 30 days, then that is an affirmative defense and the government can impose penalties. On the other hand, if you do act with willful neglect, then the penalties are higher. Not only that, but in the case of willful neglect, the OCR must impose penalties. So you don't want to engage in willful neglect. If you engage in willful neglect, but you correct it within 30 days, you still got to pay $15,000 to $71,000 per violation. And if you engage in willful neglect, but you don't correct it because you don't like HIPAA or the horse it rode in on, well, the penalties are a mandatory penalty of at least $71,000 up to about $2 million per violation. Now, remember also that when it comes to that willful neglect, those penalties can add up awfully quickly because each person whose information is improperly violated, or improperly breached, that's a different HIPAA violation. In addition, to the extent that HIPAA requires you to have a certain policy or procedure in place and you didn't have that, for each day that that's not in place, that can also be a separate violation. So those penalties can add up awfully quickly. Fortunately, however, the OCR is somewhat forgiving, and we don't have a ton of OCR settlements, but we do have a bunch. And if you go on the OCR's website, you can see the recent settlements. The top HIPAA risks right now, the ones that are really coming down in big ticket penalties, are certainly cyber attacks and security rule violations, because those are going to affect tens of thousands of patient records. In addition, there's also right of access violations. We'll talk about that a little bit later, but the government has a right of access initiative where they're going after people for HIPAA right of access violations. Now, those aren't the only ways that there's enforcement. You also have to self-report violations, your violations of the under the breach notification rule. So you're wondering how the government would ever catch you? Well, one reason is you've got to self-report. In addition, in the future, if individuals recover a portion of those penalties, well, in the future, individuals will be able to recover a portion of those penalties. That was part of the HITECH Act, but the government's never got around to implementing the regulations that would allow those patients to recover a portion of the penalties imposed for HIPAA violations. But in 2022, the government issued a proposed notice or a notice of soliciting input about how they should implement those. So we think that those rules allowing the patients to get a portion of that recovery will come out soon, which could increase their incentive to report HIPAA violations. So watch out for that. Even if you're not worried about the government coming after you, you've got to be worried about your own job, because employers have an obligation to sanction employees who violate HIPAA. If the employer fails to do so, then that employer is violating HIPAA. There is no private cause of action, so a patient cannot sue you for a HIPAA violation per se, but they could use HIPAA as a basis for negligence, for example. And so it's possible, depending upon your state law, that you may get sued for a HIPAA violation. And finally, state attorney generals can bring their own lawsuits if they want to and get a $25,000 fine per violation, plus recover their fees and costs. What you want to do is you want to try to avoid those HIPAA penalties if you can. What you need to do to avoid the civil penalties? Well, generally, if you do the following, you're going to be okay. If you have required policies and safeguards in place, if you execute business associate agreements, you train your personnel concerning the HIPAA rules and document that training, and you respond immediately to mitigate and correct any violation and timely report a breach if a breach is required. In those situations, if you're doing those things, there's a good chance you're not acting with willful neglect, and that means that if you correct the situation within 30 days, then that is an affirmative defense to HIPAA violations. So you want to make sure that you are doing these things and documenting it to avoid willful neglect penalties. We are going to talk about those things in more detail. Let's talk first about who is covered by HIPAA. HIPAA applies to healthcare providers, but not all healthcare providers. Only those healthcare providers who engage in certain electronic transactions. If they are engaging in those electronic transactions, most of which deal with third-party payers, then in that situation, they're going to be covered by HIPAA. On the other hand, if you are a purely paper practice, well, you are an anachronism, but aside from being that, you could avoid HIPAA penalties as a healthcare provider. But HIPAA not only applies to covered entities who are healthcare providers, but it also applies to health plans. Health plans are health plans that include group health plans, employee group health plans, if you have 50 or more participants or you're administered by a third party. So for those of you who are healthcare providers, don't forget to think about, okay, well, my health plan is also a covered entity. So that means that health plan also has to comply with HIPAA if it has 50 or more participants or is administered by a third party. In the wake of the omnibus rule, business associates are also directly liable for HIPAA violations. They're not covered entities, but business associates of covered entities are directly liable for HIPAA violations. We'll talk more about that in a little bit. Well, that's who it applies to. What about protected health information? What information does this apply to? It applies to any information that's created or received by a healthcare provider or a health plan that relates to the past, present, or future physical or mental health, healthcare, or payment for healthcare to an individual, and either identifies the individual or with respect to which there is a reasonable basis to believe that the information can be used to identify the individual. It's not just their medical records. It's any information identifying them or linking them as a patient. It's just their name, even if you don't have other stuff. Their account number, even if you don't have other stuff. Any information, any individually identifiable information relating to healthcare, or payment is protected health information under HIPAA, and you got to comply with the rules. But what is not covered information? Well, information after the person's been dead for 50 years, then it's no longer protected by HIPAA. Information that you maintain in a capacity other than as a healthcare provider or a health plan is not protected by HIPAA. So even though you as maybe you're a hospital, you may maintain a whole bunch of employee health records for your own employees, but those are for employment purposes, not in your capacity as a healthcare provider, and therefore those employment records per se are not covered by HIPAA. Also, if you go in and suck out a bunch of identifiable information, then that de-identified information is no longer subject to HIPAA. That means you have to suck out things like names, dates, telephone numbers, fax numbers, email address, social security numbers, MRN numbers, account numbers, and so forth. Now, the flip side of that indicates that, hey, those things are identifiers, and if they're linked to any kind of healthcare or the fact that the person was receiving healthcare at your facility, then it's presumably going to be protected health information. All right, so that's what it applies to. What does it require? Let's talk about the use and disclosure rules. The HIPAA generally says that you cannot use or disclose protected health information. Not only disclose it outside your organization, but you can't even use it inside your organization unless you fit within a HIPAA exception or you obtain the patient's written authorization. Let's talk about some of those exceptions, the most important of which are the exceptions for treatment, payment, or healthcare operations. HIPAA says that you can go ahead and use the protected health information without the patient's authorization for your own treatment, payment, or healthcare operations, as those are defined in the rules. Treatment is very broad. It includes coordination of care, exchanging information with other healthcare providers so they can render care. Payment also very broad. It's billing insurers, it's billing the patient, it's sending them to collections. Healthcare operations is a specific defined set of functions that you engage with. It's not anything you do. It's only these specific healthcare operations that are defined in the regulations, things like quality assurance, credentialing, securing legal services, handling patient grievances. Those types of things are healthcare operations. You can use or disclose the information for your own healthcare operations. You can also disclose protected health information to another covered entity for that other covered entity's treatment and payment purposes and certain of their healthcare operations, but not all their healthcare operations. And you can only disclose information to another covered entity for that other covered entity's healthcare operations if you both have a treatment relationship with the patient, the information you're disclosing is related to that treatment, and it's limited to the first two subpoints in the definition of healthcare operations, primarily QA/QI activities or credentialing activities. Now, there are exceptions to this exception for treatment, payment, or healthcare operations. You generally need the patient authorization if you're engaging in psychotherapy notes. Now, psychotherapy notes are not mental health records. Psychotherapy notes are a subset of mental health records. It's a very narrow set of mental health records. It's basically those records that a psychotherapist or a healthcare provider uses in a psychotherapy session. It's their internal notes, not the notes that ultimately make their way into the medical record or the mental health record. In addition, you need the patient authorization. Even though HIPAA allows you to use or disclose the information for treatment, payment, or healthcare operations purposes without the patient's consent, if you agreed with the patient that you would not use or disclose their information for treatment, payment, or healthcare operations without the patient's authorization, then you got to comply with that. My advice is don't ever do with that. Don't ever agree with your patient or tell your patient that you won't use or disclose their information unless they authorize it. That's going to bind you, prevent you from using these other exceptions that are otherwise very broad. Okay, that's the first and most exception. The next exception, HIPAA allows you to use or disclose protected health information or disclose protected health information to family members or others involved in the patient's care or payment for their care. Okay, you don't need the patient's authorization under these circumstances. If the patient's present, you may disclose if the patient agrees to the disclosure or has a chance to object and does not object, or it's reasonable to infer from their agreement from the circumstances. So for example, if a patient comes in with their spouse, then you can assume that you can talk in front of the spouse and maybe disclose information to the spouse because the patient apparently doesn't care if you do that in their presence. On the other hand, if the patient's unable to agree, maybe they're incompetent or they're not available, not around, you may only disclose the information if the patient has not objected to your disclosures to this family member or others involved in the patient's healthcare, and you determine it is in the best interest of the patient to do so, to make that disclosure. For example, if a patient wants to pick up or a family member wants to pick up a patient's prescription, or you're going to talk to the spouse of a family member, something like that. As long as the patient has not objected, then you're probably okay in making those disclosures. But if you are going to disclose that information to the family member, the friend, the person who's involved in the patient's healthcare, you've got to limit the disclosure to the scope of that person's involvement. And importantly, this provision in the wake of the omnibus rule continues to apply even after the person's dead. So if the patient's dead, you can still make disclosures to family members so long as the patient didn't object and that person was otherwise involved in the patient's healthcare while the patient was alive. All right, next exception is the facility directory exception. This is the one that allows the hospital, for example, to have their pink ladies. And you go in, you want to visit your friend in the hospital, you can go up to the desk and say, hey, I'm here to visit John Smith. And as long as you ask for that patient by name and the patient hasn't told the hospital they want to be a do not publish, then in that situation, that pink lady can go ahead and give you the name and location in the facility and provide general information concerning their general condition. But it only applies if the patient hasn't objected and the person visiting asks for the person by name, and you're limited in the information that you can go ahead and disclose. HIPAA also allows you to make disclosures to the extent another law requires a disclosure. So if a law requires you to disclose, for example, to disclose child abuse or neglect, or to disclose treatment to certain victims of a crime, then HIPAA says, fine with us, as long as this other law requires a disclosure, you can go ahead and make that disclosure required by the law, just to make sure you're only disclose the information and under the circumstances where the law requires it. On the other hand, if a law simply allows the disclosure but does not require the disclosure, then in the commentary to the omnibus rule, the OCR said, well, in that situation, you would not fit this exception because the law doesn't require the disclosure. So for example, I happen to be in Idaho, and in Idaho, there is a law that allows you to disclose, allows a doctor to disclose information to the Department of Transportation if they think a driver is unsafe. Well, this exception would not apply to that because the law only allows the disclosure. It doesn't require the disclosure. Another exception, HIPAA allows you to use or disclose the protected health information if you have a good faith belief that the use or disclosure is necessary to prevent or lessen a serious and imminent threat to the health or safety of a person or the public, and you make that disclosure to a person who's reasonably able to prevent or lessen that threat. For example, it would allow you to go to the police and report to them if you are aware of somebody who poses a serious and imminent threat of harm. But it wouldn't allow you to go on Channel 7 News or something like that or report it to Geraldo. There's another exception that allows you to make disclosures for certain public health activities. For example, reporting child abuse or vulnerable adult abuse or neglect, or making disclosures to public health authorities who are authorized to receive the information to prevent disease or injury. This is the one that, why you could make a bunch of disclosures in the COVID era, right? You could make those disclosures under this exception. There's another exception that allows you to make disclosures to agencies for health oversight purposes. This is the one that would allow you to make disclosures to for example, if the Board of Medicine wants information so that they can evaluate a licensee, this exception would allow you to make those disclosures. Or if you have CMS or the OIG showing up and wanting information to evaluate whether there is fraud and abuse going on. This is the exception that will allow you to make the disclosures in those types of situations. There's also an exception under HIPAA that allows you to make disclosures for purposes of judicial and administrative proceedings. Now, the rules differ depending upon the nature of the request. If you get an order or warrant that's signed by a judge or an administrative tribunal, then you can go ahead and provide it. The judge is the law. You just need to make sure that you are strictly comply with whatever it is they say you can disclose and don't disclose other situations. On the other hand, if you get a subpoena, discovery request, or legal process that is not signed by a judge, not accompanied by a court order, it's just signed by another attorney, maybe in a civil litigation or something like that, then the general rule is you cannot simply just provide the information. But at the same time, you can't ignore the subpoena. The subpoena still may be valid, but you can't disclose the information unless you get either satisfactory written assurances from the party issuing the subpoena that they notified the patient and the time for objections has passed, or alternatively, you can go ahead and notify the patient yourself and tell them, hey, we got this subpoena and we're going to have to respond by a certain date unless you take steps to get that quashed. The key there is to confirm that the patient has gotten notice so they've had an opportunity to object. And in that situation, HIPAA says, okay, as long as the patient had that chance, it's on them to go ahead and respond. So your obligation under HIPAA is just to make sure that the patient got notice of that subpoena and a chance to object, either by you giving the notice yourself, which is quite often the easiest thing to do, or by making sure that the party who issued that subpoena has given the notice to the patient themselves. There is also an exception that applies to law enforcement. Now, just because the police show up doesn't necessarily mean they get information. HIPAA still applies, but HIPAA has some exceptions that apply to law enforcement. If law enforcement shows up with legal process, meaning that they've got a court order, warrant, or subpoena, then these rules apply. In this situation, if it's signed by the judge or magistrate, again, you can go ahead and provide the information. If it's a grand jury subpoena, even if not signed by the judge, it's just signed by the prosecutor, you can still provide the information because everything that's done in the grand jury is confidential. On the other hand, if it's simply an administrative request or a subpoena or a summons or demand that's authorized, if the demand is authorized by law, then you can go ahead and produce it if that information you get in the person seeking that verifies that the information is relevant and material to a legitimate law enforcement inquiry, the request is reasonably specific, and de-identified information could not be used. Now, recently the OCR clarified this as of last year. A lot of times you'll get investigators or the police or prosecutors who try to rely on this and say, hey, I'm here conducting an investigation. I just want you to provide this information. It's an administrative request. Well, recently the OCR clarified that's not enough. It's not enough that it's simply an administrative request. It has to be a process that's required by law, that it requires you to respond during the law, not just simply because somebody shows up and asks for it, but they have to come in with like a civil investigatory demand or some other document that the law requires you to respond to, okay? So just be aware of that change. Now, there are other situations where law enforcement may show up and want information that's not accompanied by any kind of formal request or an order or warrant. In that situation, HIPAA generally says you can't provide it unless you can fit with one of these exceptions. There's exceptions that would allow you to disclose information to law enforcement to report a crime on your premises. So if you've got a patient who's beaten up a staff member, you can report that. If you get a request from the law enforcement that they need information to help you identify or locate a suspect, fugitive witness, or a missing person, then you can disclose limited information. But it's basically just limited demographic information like, name, date, appearance, things like that. If you get a request from law enforcement about the victim of a crime, you can make disclosures. If the victim agrees or if the victim's unable to agree, you get information from the law enforcement that, hey, we need this information immediately in order to protect other people. If the law enforcement shows up with a patient in custody or they bring in somebody from the local jail, then you can go ahead and provide information to the law enforcement to the extent it's necessary to provide health care to that person who's in custody, or for the health or safety of the others, the officer, others in the correctional facility, or for the operations of the correctional facility. Those disclosures to law enforcement, it's sometimes helpful to go to this particular document. The HHS and the Department of Justice actually published a guide for law enforcement officers about HIPAA. I found it helpful if you have that, and if you get law enforcement who shows up and threatens you for not disclosing information to them, it's helpful if you give them a copy of that so they know that, no, it's not just us, this is the law. We can't disclose unless we can fit within one of those exceptions. There's also an exception that allows you to disclose information to a workers' comp, under a workers' comp claim, to the extent that that disclosure is allowed by relevant state laws. There are certain other exceptions that apply to specialized functions like disclosures to coroners, to funeral directors, for organ donation programs, for certain research purposes, for military personnel, or for national security and intelligence purposes. For those, just look at the regulations, talk to your privacy officer, and make sure that for these, like all of those others, there are certain limits that or certain issues that you have to address or make sure that you satisfy before you make the disclosure. Just check those before you go ahead and use the produce those information. All right, let's talk about the new reproductive rights rule. This took effect late last year, and as far as we know, it's still in effect. To be honest, I thought that the new Trump administration would probably get this by now, but it's still on the OSAR's website. So technically, you still looks like you have to comply. So to understand this reproductive rights rule, or this reproductive health rule, you need to step back and understand the context. Remember, after the Jackson Women's Health case come down and they did away with Roe v. Wade and abortion, the Biden administration was concerned about situations where a patient may, abortion's illegal in one state, they may go over to another state to get a legal abortion, but the Biden administration was concerned about prosecutors from that first state getting information from that other state where the abortion was legal in order to prosecute the patient for getting that care. So in order to address that situation, the Biden administration came up with the reproductive health information rule. It applies to reproductive health care information, or what I refer to as RPHI. And it basically says it applies to information concerning reproductive health care, which is any health care that affects the health of an individual in all matters relating to the reproductive system and to its functions and processes. It's not just about abortions. It's anything dealing with the reproductive system, whether it's male or female. It applies not only to the provider or business associate who engaged in that reproductive health care, but any healthcare provider or business associate who has that RPHI, it is potentially subject to this rule. What does the rule require? Well, the rule says that if the reproductive health care was legal where it was obtained, then covered entities and business associates may not use or disclose that reproductive health care information for purposes of a criminal, civil, or administrative investigation, or to impose liability on that person. Now, note that it only protects information if it pertains to healthcare that was legal where it was obtained. It does not protect reproductive healthcare information that was illegal where it was obtained. Well, how do you know whether or not that is the purpose for why it's being sought? Is it really being sought for purposes of criminal, civil, or administrative investigation? How do you know that? Well, you know it because you've got to obtain an attestation from the person seeking that RPHI to confirm whether or not, why they're seeking that information, to confirm that they're not seeking it for criminal, civil, or administrative investigation or liability. Note that the ability to use or disclose that information doesn't depend on its nature as RPHI. Instead, it depends on the purpose for which the information is sought. Specifically, if it's being sought for one of these exceptions, we went through those exceptions under HIPAA that allow you to make disclosures for law enforcement purposes, for judicial or administrative proceedings, for health oversight activities, or disclosures to coroners and medical examiners. If you get a request, and that request is seeking this information for one of these purposes, then you are obligated to obtain that required attestation before you can disclose the information. And remember, you've got to know why they're seeking that information before you can make the disclosure under HIPAA. And if you learn, okay, the reason is because if it's for health oversight activities or for judicial or administrative proceedings or for law enforcement purposes, you've got to ask that person to provide an attestation. What does that attestation have to have? Well, it has to contain these elements that are set forth in the regulations, including a statement that the use or disclosure is not for a purpose prohibited by the rule. including that it's not for purposes of criminal, civil, or administrative liability. If they are unwilling to provide that, then you can't go ahead and provide that information if the healthcare was legal where the healthcare was rendered. Well, you could create your own attestation, or it's easier if you just go on and the OCR has created a model attestation. You can use the model attestation that's on the OCR's website. And that's what you would use when you get a request for those, health oversight, judicial administrative proceedings, or law enforcement. If you get that request, they're seeking reproductive health care, then you need to seek that attestation. Now, like I said, I don't know how long this is going to be in effect, this reproductive rights or this reproductive health rule. It is subject to challenge. In fact, a federal district court in Texas enjoined its use, but it only applied to the parties in that particular case. There are a bunch of other lawsuits that are out there pending. We don't know what's going to happen, whether the courts will issue a broader nationwide injunction, or it may be that the Trump administration simply decides to withdraw from those cases so it doesn't defend against those cases, thereby resulting in an order from the court striking down the rule. We don't know how it's going to play out, but in the meantime, the rule's on the books and you need to comply. All right, so let's back up. Big picture, HIPAA generally says you can't use or disclose protected health information unless you fit within a HIPAA exception or you have the patient's authorization. Well, what does it take to have a valid patient authorization? Well, generally, in order for it to be a valid authorization, the patient or the patient's personal representative has to sign a written document. It has to contain certain elements and certain statements. I'm not going to go through those today, but you may want to call out your authorization forms you're using, comparing to 45 CFR 164.508, and make sure that it still contains those required elements. If not, then it's technically not a compliant authorization. Now, you generally have to have a valid written authorization for certain uses. Remember, if it's not accepted, then you generally need the authorization, even if it might otherwise fall within an exception. HIPAA requires a valid written authorization for use or disclosure of protected health information for psychotherapy notes, for certain marketing purposes, if you want to sell the PHI for certain research purposes, or for any other uses or disclosures you want to make, unless you've got a regulatory exception that applies. A word about employee vaccinations, tests, IMEs, those types of things. A lot of you think about, okay, when we're doing these employee vaccinations or when we're doing IMEs, we're really not acting as a healthcare provider, but HHS disagrees. If you are acting as a healthcare provider, then you are a healthcare provider for purposes of HIPAA, and as long as you're engaged in those electronic transactions, then HIPAA applies to whatever you're doing as a healthcare provider, including vaccination, IMEs, or the like. Those are covered by HIPAA. That means you cannot disclose that information to the employer unless you fit within a HIPAA authorization. A HIPAA exception, there is none. So you would need to have the patient's authorization before you can make those disclosures back to the employer. Now, what you're going to want to do is you're going to want to, when that patient shows up, in order to get this IME, the drug test, the IME, those things, you're going to want to have the patient sign an authorization up front that allows you to use or disclose the protected health information, because that's the whole purpose that they're there. You may condition that exam on their provision of an authorization. This is a different rule. The general rule is you can't condition treatment on an authorization, but this is an exception. If the whole purpose of you conducting that healthcare is so that you can get information to disclose to another party, you can condition that care on the patient providing that authorization. And if you rely on that authorization to go ahead and provide that care, then the patient can't withdraw that after the fact. So just be aware of these employee vaccination tests. Just remember, HIPAA still applies, and that generally means you need the patient's authorization before you can make the disclosure. HIPAA also generally requires an authorization to engage in marketing. The key here to understand this is, well, what is marketing for purposes of HIPAA? Marketing is defined as a communication about a product or service that encourages the recipient to purchase or use a product or service, just like you'd expect, except it excludes the following from the definition of marketing. So the following is not marketing, and you do not generally need an authorization to use or disclose the information for these purposes. to describe a product or service provided by the covered entity. So you can use the information to describe your own products or services. You can also use it for treatment or healthcare operations of another entity, including describing some service or drug or thing that you think that the patient might need, or for case management, care coordination, or to direct or recommend alternative treatment therapies or providers. Those are not marketing, so you don't need the patient's authorization to use or to disclose the protected health information for those purposes unless you receive financial remuneration for making those communications. If you have a drug company that's paying you in order to make those communications, then that would convert it into marketing, and you would generally need the patient's authorization to use or disclose their information for that purposes. There are some other exceptions to the marketing rule, like if you're giving some information in a face-to-face communication or something like that, then there are some other exceptions, but that's the general rule for marketing. The bottom line, if you're using it for treatment purposes or to disclose your own products or services, then that's generally not marketing unless you're getting paid by a third party. You generally have to have the patient's authorization if you want to sell their protected health information. You also need the patient's authorization if you are going to use their information to engage in fundraising, and there are specific rules about using that. You also need the authorization generally if you're going to use it for the patient's information for research purposes, unless you jump through certain hoops involving the Institutional Review Board or Privacy Committee. The government has published some very helpful guidance on research purposes. If you're engaging in research using protected health information, you ought to become familiar with that. All right, let's talk about parents and personal representatives. To what extent can parents get information or personal representatives? Under HIPAA, you treat the personal representative as if they were the patient. That means because you can make disclosures to the patient, you can also make disclosures to the personal representative. Not only that, because the personal representative can exercise the patient rights, then you are obligated to disclose the information to the personal representative if they ask for that information. They have the right to access that. So the key is, well, who's a personal representative for purposes of HIPAA? If the person has the authority to make healthcare decisions for that patient, they are the personal representative for purposes of HIPAA, and they would be able to access that information, and you can disclose the information to them. So you have to understand your state law to identify, well, who is authorized to make healthcare decisions for that individual. Now, there are limited exceptions that would allow you to not treat that person as the personal representative. For example, in the case of a minor, if the minor can consent to their own healthcare under state law, then you don't need a personal representative. That the parent can't consent for their behalf because the minor can consent on their own. Therefore, the parent would not be the personal representative. If the minor obtains care at the direction of a court or person appointed by the court, then you don't need parental consent, and the parent's not the personal representative for purposes of that particular care. If the parent agrees that the provider may have a confidential relationship with the patient, then you can decline to disclose that information to the parent. Or if you determine that the treating the personal representative of the patient is not in the best interest of the patient, for example, it's an abuse or neglect situation, that making that disclosure to the parent would endanger the child, then in that situation, you can decline to treat the parent as if they were the personal representative. In these situations, make sure you're aware of state law, because there are state laws out there that require disclosure to parents. In that situation, you'll have to do a complicated analysis to evaluate whether HIPAA trumps that state law. So, just a brief recap then, let's talk about, okay, so when can I disclose information to family members or other personal representatives? Well, again, if they are the personal representative, then they generally have the right to access the information. You can give it to them. Even if they are not the personal representative, you can make the disclosure to the extent it's necessary for treatment, payment, or healthcare operations. Note that that includes payment. If the patient's not paying and you need to call their mom in order to get payment from the mom, even though the patient's an adult, if the mom's still a guarantor, then you can still go ahead and contact mom for payment purposes. If the disclosure is to a family member or others involved in the care or payment for the care, then you can go ahead and make the disclosure so long as the patient did not object and you determine it's in the patient's best interest, and you limit the disclosure to the scope of that person's involvement. Or you may make a disclosure to family or others if there's another exception that applies. For example, maybe you feel like it's necessary to make a disclosure to the family to avert a serious and imminent threat of harm to the patient or a third party. All of those are summarized in a helpful guidance from the OCR. If you need that about disclosures to family members, you can access that at that website that's on your screen. All right, let's talk about business associates. HIPAA allows you to disclose information to a business associate if you have a valid business associate agreement, a BAA. So in the case of a covered entity, you can make disclosures to your business associate. A business associate can further disclose to its subcontractor business associates if in both of those cases there are, excuse me, if there are applicable valid business associate agreements in place. If you make disclosures without having a valid business associate agreement in place, well, guess what? That's a HIPAA violation. Not only that, but there are some decisions by the OCR. I think those decisions are wrong, but nevertheless, there are some decisions by the OCR where the OCR has taken the position that, hey, you can be basically vicariously liable. So if you don't have a business associate agreement in place, that business associate screws up and breaches your information, then guess what? You as the covered entity, you're liable for what that business associate did. Again, I think that's the wrong analysis, but nevertheless, there are some decisions out there that suggest that's the way the OCR views it. So you want to make sure as a covered entity or as a business associate that you have business associate agreements in place. The first question is, well, okay, who are business associates? Business associates are those entities that create, receive, maintain, or transmit protected health information on behalf of the covered entity to perform a function for the covered entity. If you're contracting with another entity to do something with your information on your behalf, then chances are that's going to be a business associate and you're going to need a business associate agreement. Same thing for business associates. If the business associates are subcontracting out those duties, those services, they're going to need a business associate agreement with that subcontractor. That business associate agreement must contain certain required terms and statements. Among other things, it's got to identify the permissible uses, and it's got to pass the limits of the business associate agreement on to any subcontractors. For more information about the requirements, you could crack the 45 CFR 164.520 and look at the requirements for a valid business associate agreement. Actually, that's in 504. I'm sorry, 164.502 and 504E. Or alternatively, you can go to an article I wrote that has a checklist for the required elements for a business associate agreement. It might be well for you to, if you haven't looked at it recently, compare your business associate agreements to the requirements under HIPAA to make sure that they're still valid and they don't have a bunch of stuff that you don't need. The government has actually published sample business associate contract language, but I'm not a fan of it. It imposes more obligations than you're really required to assume under HIPAA. So I'm not a big fan of the government's sample language. I prefer other language that more closely tracks with just what's required by the regulations. Well, we've talked about who are business associates. Who are not business associates? Well, members of the covered entity's workforce, your own employees, they're not business associates because you control what they do. And so you don't have to have a business associate agreement with members of your workforce. Entities who do not handle PHI as part of their job duties, they're not business associates, even though they may come in contact with business associate information. For example, you may have janitors who come in, but their job is not to pick up the trash and also look through your protected health information. So they would not be your business associates. It's appropriate to have a confidentiality agreement with them, but you don't need a business associate agreement with them. Entities that receive PHI to perform functions on their own behalf are not business associates. So for example, you do a lot of banking where you pass along patient checks and stuff. They get protected health information, but they're not performing those functions on your behalf. That they're operating as a bank. The insurance companies aren't collecting that information or paying that information on your behalf. No, they're acting as a third-party payer. In those situations, they are not acting as your business associate, so you don't have to get a business associate agreement with them unless they are also performing certain services on your behalf as your business associate. Other healthcare providers who are just simply providing treatment, they're not your business associate. You don't need a business associate agreement with them. Data transmission companies that do not routinely access protected health information, like the phone company, if they're just simply a conduit, but they never access the information or maintain the information for any significant period of time, then they're not a business associate. On the other hand, if you do have a data transmission company or you're storing stuff on the cloud, protected health information on the cloud, those cloud service providers are business associates, even if they don't have an encryption key, and you would need a business associate agreement with them. It's important for you to make sure that you understand the business associate's obligations so that you don't assume liability for them. Generally, business associates or covered entities are not liable for the business associate's misconduct so long as that business associate is acting as an independent contractor and not as the agent of the covered entity. You want to make sure your business associates confirm that that business associate is acting as an independent contractor, that you are not exercising control over them, therefore they are not acting as your agent. Be careful about assuming too much control. I see some business associate agreements where the covered entity has to control lots of aspects of the relationship, including reviewing policies and procedures. By doing that, you may unintentionally step over the line and exercise control such that that business associate is now your agent and you are vicariously liable for what they do. So be careful about exercising too much control over that business associate. All right, let's talk about actually making the disclosure. We've talked about, okay, when can you do the disclosure, to whom you can provide the information. What about how you go about doing that? Well, first, even though HIPAA may allow you to make the disclosure, you've got to take reasonable steps to verify that the entity to whom you are making that disclosure is the appropriate person who can receive that. Now, that doesn't mean that you bring them in to do blood tests or do a big background check. You just ought to take reasonable steps to verify who they are. So if you get a mom calling in, you don't know whether that's mom or not. You're going to want to verify that she is mom and that she's entitled to that information. You might ask her, for example, to tell you the son's social security number or birth date, or do something else to take reasonable steps to verify that that person is who they say they are. You've also got to, in the case of if you've got a patient portal, in the OCR guidance, they say that you should include appropriate access controls, so not just anybody can access that you can verify who the person is who's seeking that by passwords or things like that. Next, even though HIPAA would allow you to make the disclosure, in general, you can't disclose more than is minimally necessary for that permitted disclosure. So if HIPAA says, okay, yeah, you can disclose this information for payment purposes, you've got to limit the amount of information you disclose for payment purposes, and you can't disclose a lot more information than is otherwise minimally necessary for that permitted purpose. Now, that minimum necessary standard does not apply to certain disclosures. For example, disclosures to the patient. You don't have to decide what the patient is entitled to. Other providers who request information from treatment. You don't have to decide what information that other provider really needs. That would inhibit effective patient care. If you get a disclosure per the individual's authorization, you can disclose information per the authorization. You don't have to second guess the patient. If the disclosure is required by law, you can disclose the information required by law, but just don't disclose more than is required by the law. On that minimum necessary standard, I don't have it on the slide, but you're also required to have role-based access policies. So you should have policies in your organization that confirms, okay, these types of people can get this type of information to perform their functions. Let's talk about patient rights. HIPAA not only protects patient information, but it also gives patients certain rights concerning their information. The first right they have is they have a right to receive a notice of privacy practices that explains to them how you're going to handle their information. That notice, the requirements are all set out in 45 CFR 164.520. If you haven't updated your notice of privacy practices recently, you should pull that up and update it to ensure that that notice contains the required statements and the required elements so that you can comply with those notice requirements. Direct treatment providers, for those of you who have a direct treatment relationship with the patient, you've got to give a copy of that notice to your patients by no later than the first date of treatment. If you engage with that patient electronically, then you've got to have it set up so that you're providing that notice at that first interaction. In addition, you've got to post notice of that notice of privacy practice in prominent locations in your physical address, and you've also got to post a notice of that on the website. When that patient comes in, you've got to make a good faith attempt to obtain the patient's acknowledgement that they received a copy of that notice of privacy practices. Now, under the proposed rules, the proposed HIPAA rules that are pending, that good faith attempt language will go away, but in the meantime, we've got that. Now, there are some pending rules out there, or some recently enacted rules, including the reproductive health rule, that will require you to update your notice of privacy practices, but they've given you until February 26th to do that. I think that's because they're going to come out with the new HIPAA rules, the amended HIPAA rules, including perhaps the security rules, by February 26th. And so they're giving you time to come out with those new rules so that you can update your notice all at once. But just realize that's going to be coming down the pipe. The second right a patient has, they have a right to request restrictions on the use or disclosure of your information for purposes of treatment, payment, or healthcare operations. Now, wait a minute. Think about that. Didn't I just tell you that you could use or disclose protected health information for purposes of treatment, payment, and healthcare operations without the patient's authorization? Yeah, you can, but this rule gives the patient the right to request restrictions on your use or disclosure for treatment, payment, or healthcare operations. But guess what? You don't have to agree to the restriction. It says that the patient has a right to request it, but you don't have to agree. And my advice is never agree. Don't ever put anything in your documents that says something to the effect that we will only make disclosures if you authorize it, because you don't live up to that. You make disclosures all the time to like health insurers or collection agencies and stuff like that, and you don't want to have to get the patient's authorization to make those disclosures. So don't ever agree to those restrictions. If you do agree to those restrictions, you got to abide by it. And that means you can't disclose those information for treatment, payment, and healthcare operations contrary to that agreement unless you cancel that agreement. And even then, it only applies to information that's created after the date that you cancel it. So go back and look at your documents. Make sure you're not doing anything that suggests that you are limiting your right to use or disclose protected health information for treatment, payment, or healthcare operations. Now, there is one limited exception to that, and that is a patient does have a right to tell you not to disclose your information to your health insurer as long as the patient paid for that episode of care themselves. So if the patient or somebody else on the patient's behalf paid for that episode of care themselves, they can tell you, don't disclose this information to my health insurer for payment purposes. And if that's the case, then you can't make that disclosure to the health insurer. Now, that's a real hassle to try to carve out that information and make sure health insurers don't get that information. So my advice is don't bring that up with the patient unless the patient affirmatively asks you about it, because if they don't ask you about it, then they probably won't request it and you'll be good. Now, for those of you who are savvy, you might recognize, this may create a HIPAA loophole, because for certain of your payers, it requires that you submit the claim to the payer. But if you want to just submit the claim to the patient and have the patient pay for themselves, then this HIPAA loophole, this is a loophole that would allow you to do that and not submit the claim to the insurer, despite contrary contract language, or to Medicare, because if the patient tells you they want to pay for that episode of care themselves and they instruct you not to disclose it, you can't disclose it to that payer, and therefore you wouldn't have to make those disclosures despite the contract language. Now, that won't apply if there's another law, not a contract, but if there's a law that requires you to make the disclosure to the payer, then you can go ahead and make that disclosure to the payer no matter what. But just realize that if the patient pays for that episode of care themselves and tells you not to make that disclosure to the insurer, then you can't. A patient also has a right to request communications in alternative locations or alternative means. So they may come in and say, hey, instead of sending this information to my home address, I want you to send it to this other place. Or instead of putting it on just a postcard, I want you to put it in a sealed envelope. You have to comply with those types of requests, and you may not require an explanation of why. A word about communicating via email or text. The HIPAA security rule generally says you can't use or disclose protected health information via unsecured means. That means unencrypted email or unencrypted text, which are most of your emails or texts. But the HIPAA privacy rule says the patient has a right to request communications by alternative means or alternative locations. So if the patient asks you to communicate with them via unencrypted email or text, then you can go ahead and do that, despite the security rule. You just want to document that the patient requested that or consented to your use or disclosure of protected health information via unsecured method. Otherwise, you shouldn't be communicating with the patient via unsecured email or text. And by the way, this exception only applies to communications with the patient. It would not excuse your use of communicating with staff members or other providers via unsecured email or unsecured text. A patient also has a right to access their protected health information. This is a big one. The government is actively enforcing this. So the patient generally has a right to inspect or obtain a copy of the protected health information, but not all their information, only their information in a designated record set. A designated record set is basically the information that's used to make decisions about a healthcare's payment, a patient's payment or treatment decisions. Now, there are certain exceptions. You may deny a patient access to that information if that information is outside the designated record set. For example, it's not payment records, but it's maybe peer review records or QA, QI, that type of stuff. Psychotherapy notes, they're not entitled to access psychotherapy notes. Remember, that's not mental health records. That's psychotherapy notes, which is a very limited subset of mental health records. If the information is prepared in anticipation of litigation, if the information was provided under a promise of confidentiality, or if the information or access you determine that it would result in substantial harm to the patient or some other person, then you can decline to provide the patient with access to that. But in that last situation, you've got to give the patient a right to have that decision reviewed by an independent third party. If you get that request to access, you've got to respond and provide that information requested within a 30-day period. You may get one 30-day extension if you need it. The government has published very helpful guidance on the patient's right to access. This really is required reading. If you haven't read this recently, you need to go to the government's website. You need to be familiar with it because they address a whole bunch of issues dealing with the right of access, including the form and format, how much money you can charge the patient for the right of access, and all of those types of things. If you deny a person's access to their information, you've generally got to explain to them why and jump through some additional hoops. Now, a patient, as part of their right of access, the HIPAA rules do allow the patient to not only get the records themselves, but for the case of electronic records, they can direct you to send electronic records to a third party. And they don't need a HIPAA authorization for that. They just need to give you a request in writing that's signed by the patient or the personal representative that clearly identifies the recipient and tells you to disclose or tells you where to send those records. And as long as those records are electronic form, then you've got to go ahead and send those records per that patient's request. This is part of the request to access, so you've got to respond within the 30-day time period, and you've got to provide it in the form and format requested. In the SIOX case, the court said that those requirements do not apply to those requirements only apply to the production of electronic information, not information that's paper records that are set by a third party. They also said that those limits in that size case, that the limits that limit the amount that you can charge to a patient do not apply to these requests to submit the information to a third party. A patient also has a right to request an amendment of their protected health information, but they only have a right to request the information. They don't have a right to actually get the amendment. You can deny the amendment for any number of reasons, including if the information is not in their record set, if it's not subject to the patient's access, or most importantly, if the record's accurate and complete. You don't have to amend it if it's accurate and complete, but you do have to respond to the patient. You generally have to act on the request within 60 days. You may obtain one 30-day extension. If you deny the request, you've got to notify the patient, and the patient then has a chance to have a statement of disagreement attached to their medical record. It becomes part of the medical record, and you've got to notify other people, a bunch of other stuff. Just remember, if you have that request for amendment, look at the rules, make sure you're complying with that. Finally, a patient has a right to receive an accounting of disclosures of protected health information that they've made, but not all disclosures, only improper disclosures and certain disclosures that are made under the exceptions in 164.512, including like disclosures to public health agencies or for law enforcement, things like that. You've got to track those accountings, so if the patient does come in and request that, you can provide that accounting of disclosure log to the patient. All right, let's talk about certain administrative requirements. The HIPAA privacy rule requires that you designate HIPAA privacy and security officers in writing. So whoever is your privacy and security officer, you've got to have those designations in writing. So if the government shows up, they know who to ask for. In addition, you've got to implement written policies and safeguards, covering the things we've talked about. You've got to train your workforce and document that training, new workforce members as they come on and periodically thereafter for others. You've got to respond timely if a person complains about HIPAA violations, and you've got to take affirmative action to mitigate any potential HIPAA violations. You've also got to maintain the documents that are required by HIPAA for 6 years. Now note, that is not maintaining medical records for 6 years. It's just the documents that are required by HIPAA, such as notice of privacy practices, the HIPAA authorizations, designations of privacy officers, those types of things. You've got to maintain those for 6 years. All right, a couple of other issues out there. As I mentioned a couple of times, there are some proposed rules, some proposed revisions to the privacy rules. Those have been pending since 2021. They haven't come out yet. We anticipate that they'll come out this year, so watch out for those. In addition, the government has cautioned about the use of the HIPAA privacy rules and how those might be violated by online tracking, particularly if you're collecting data behind an authorized or an authenticated web page, and then you're sharing that information with a third party who is using that information for purposes that are not permitted by HIPAA, including online tracking and stuff like that. That could violate the HIPAA privacy rules. So you may want to take a look at those, the guidance that the government's issued on that, and make sure you're complying with that. All right. I'm going to take a few minutes now and talk about the HIPAA breach notification rule. We've talked about all those rules about disclosures and things like that. What happens if we did have an improper breach? Well, the key to understanding the breach notification rule is understand what the definition of a breach is. If there is a breach of unsecured protected health information, then the covered entity must notify each individual whose unsecured information has been or reasonably believed to have been accessed, acquired, or used or disclosed. They've also got to notify HHS. The only difference is the timing when you make that disclosure. And if the breach involves more than 500 persons in a state, you've got to identify local media or notify local media. Business associates, on the other hand, they don't have the obligation to notify the individual or HHS, but they do have to notify the covered entity, so the covered entity can then go ahead and make the required notices. As I mentioned, the key to the breach notification rule is understanding what a breach is. A breach is the acquisition, access, or use or disclosure of protected health information, unsecured protected health information, in violation of the privacy rule. A violation of the security rule does not trigger the breach notification. It only has to be a violation of the privacy rule. And a privacy rule violation is presumed to be a reportable breach unless the covered entity or business associate demonstrates that there's a low probability the information has been compromised, whatever that means. How do you know that? Well, you have to do a risk assessment of the following 4 factors. First, the nature and extent of the information involved. If, for example, information got out that a person was a patient at a hospital, a general hospital, but there's no information, no financial information, no information about the specific diagnosis or anything. All you know is the person went to the hospital. Well, the government in some commentary suggested, well, yeah, was it a breach? It was, but you could determine that it's a low probability the data has been compromised, so it's not reportable. The next factor, who received the information? They gave the example of, let's say you fax a record to the wrong physician. You immediately recognize it. You call that other physician. The physician says, oh yeah, no worry, we all been there. They agree to destroy the information. In that situation, the government said, hey, in that situation, it went to another entity that's, covered by HIPAA. They know what the rules are. There's no real risk, and there's a low probability that the data is going to be compromised. You could conclude that it's not reportable in that situation. That's different than just sending that down to, Guido at the local loan shark. The next one is whether the information was actually acquired or viewed. That's an important factor. Now, if you lose data on which protected health information is maintained, then presumably that's going to have been acquired or viewed, and therefore it's probably going to be reportable. The fourth factor is the extent to which the risk to the PHI has been mitigated. If you jump on it immediately and quash it before anybody really has a chance to look at it, you can factor that into determining whether or not there's a low probability the data is compromised, so whether or not you need to go ahead and make the disclosures. Now, there are certain exceptions to those rules. First, if you lose data that's been secured, well, it's not unsecured protected health information, so there is no breach reporting requirement. How do you secure data? Well, you either completely destroy it, so there's no possibility of its disclosure, or in the case of electronic information, it's encrypted. And if it's adequately encrypted, then it's secured. And even though you lose information that's encrypted, if it's adequate, then it's not reportable breach. Incidental disclosures are not considered as breaches because they don't violate the privacy rule. What are incidental disclosures? These are the things that, sometimes something just happens, no matter how many safeguards you put in place. If you do put in place reasonable safeguards and somebody just happens to see something or overhear something in the hallway, as long as you had reasonable safeguards in place, then that is an incidental disclosure and it's not reportable. It's not a violation of the privacy rule, therefore it's not a reportable breach. Breach also is defined to exclude certain internal disclosures that may be made as long as no further disclosures are made, or if you're able to retrieve the information before anybody else was able to look at it, then it's determined not to be a breach. Let's assume that you went ahead and you had a breach, then HIPAA requires you to give notice to the individual without unreasonable delay, but no more than 60 days after the date of discovery. That doesn't mean that you can sit around for 60 days to give the notice. No, you're expected to jump on that as soon as possible, do your investigation, and provide the information as soon as possible. 60 days is the outside, but if you complete your investigation and can provide the information sooner, you are expected to do so. And quite frankly, you're going to want to do it within the 30-day period, because if you do it within 30 days and you didn't act with willful neglect, it can be an affirmative defense to any penalties. That notice to the individual has to go by mail to them, first-class mail, unless they agree to receive it by email. You must that breach notification has to contain certain elements that are set forth in the rules. So if you're going to do that breach notification, look at the rules and make sure your breach notification contains the rules. When you have a breach, you're also going to have to notify HHS. If the breach involves fewer than 500 persons, you've got to submit it to the HHS at least annually, no later than 60 days after the end of the calendar year, which is usually March 31st, depending on whether or not it's a leap year. On the other hand, if the breach involves 500 or more persons, then you're going to want to have to go ahead and provide the notice within 60 days after the date you knowingly discovered the breach. You submit that report to HHS by going to this website, and it walks you through the information. You submit that electronically. If the breach involves more than 500 persons, you're added to the HHS wall of shame that lists everybody who had breaches involving more than 500 persons. Also, if the breach involves more than 500 persons in a particular state, you've got to notify media of the breach, but for heaven's sakes, don't compound the problem by disclosing protected health information as part of that notice. If you're a business associate and you discover a breach, then you've got to notify the covered entity so the covered entity can go ahead and give those notices. All right, that is a very brief review of the primary portions of the privacy rule. If you want additional resources, you can go to the government's, just type in HHS OCR HIPAA, or type in HIPAA OCR, and the OCR actually maintains a very helpful web page. Or you can go to our web page, and I've got a whole bunch of publications on HIPAA, as I mentioned. Or you can always pick up the phone, I suppose, and call me. There you go. That is HIPAA. In a couple of weeks from now, we're going to be talking about the HIPAA security rule, including the new proposed rule. If you do have questions about anything that I've covered today, you can submit those questions using the chat feature, or you can shoot me an email and I'll try to respond to those offline. Otherwise, thanks very much for your participation. I apologize I went over a few minutes, but we had a lot to cover. Thanks very much.